Disclaimer. All information is directly pulled from the most current listings of United States codes at the time of uploading. No person should take the information or interpretations presented here as legal advice or advice of any kind. All legal research or requests for legal interpretations should be done individually, as all information presented can be changed at any moment. I am not a lawyer, a politician, a representative of the United States government, or an expert in any field related to any of the information being presented here. I am merely a concerned citizen hoping to bring the rules that dictate our country to light in an easier to understand fashion than is being presented to us currently. United States Code Title 1, General Provisions. Chapter 1, Rules of Construction. Section 7, Marriage. Subsection A. The text reads, "For the purposes of any federal law, rule, or regulation in which marital status is a factor, an individual shall be considered married if that individual's marriage is between two individuals and is valid in the state where the marriage was entered into, or, in the case of a marriage entered into outside any state, if the marriage is between two individuals and is valid in the place where entered into and the marriage could have been entered into in a state." This means marriage is strictly between two people. The marriage is valid if married in a state where it is considered valid. If married outside any state, Part 1 still applies, and the state entered into the country must also accept the validity of the marriage, like Part 2 says. Subsection B. The text reads, "In this section, the term state means a state, the District of Columbia, the Commonwealth of Puerto Rico, or any other territory or possession of the United States." This means state for the purposes of marriage, and this section refers to a state of the United States of America, the Commonwealth of Puerto Rico, any other territory or possession of the United States. Subsection C. The text reads, "For purposes of subsection A, in determining whether a marriage is valid in a state or the place where entered into, if outside of any state, only the law of the jurisdiction applicable at the time the marriage was entered into may be considered." This means when determining if a marriage is valid, only laws and jurisdictions in place at the time of the marriage will be used. Thank you. Please go to the Office of the Law Revision Council for a complete list of up-to-date versions of United States codes. The link is in the description below. https://uscode.house.gov. That's https://uscode.house.gov. Please like and subscribe for more releases and updates.